at the time that this matter was called out for hearing, it was about 11 a.m. This is because the court sought to indulge the prosecution after being notified that there was no prosecutor in court. The prosecutor failed to appear in court. The prosecutor, who is Ms. Wangia, failed to appear in court on the 8th of November 2023. Despite efforts to reach her, both by the court assistant and the state counsel who was holding her brief, her phone was switched off. The court was forced to adjourn this matter on the 8th of November 2023 due to the unknown whereabouts of the prosecuting counsel. This court directed that the in-charge prosecution do communicate to the court on the whereabouts of the said prosecuting counsel, Ms. Anita Wangia. Instead, this court received a letter from one Grace Murongi, Deputy Director, DPP, dated 8th of November 2023, stating that she had been directed by the DPP to take out hearing dates so as the application dated 3rd of November 2011 seeking the withdrawal of the case against accused number 10, 11, 12, and 13 be heard on priority. In the said letter, there is no mention as to the whereabouts of the prosecuting counsel. In a response thereof to all parties, this court directed that the matter shall proceed to hearing as scheduled on the 9th of November 2023, which is today. The matter was required to proceed from 9:30 a.m. The trial magistrate was informed that the prosecuting counsel had not arrived in court. This court made an allowance for the prosecuting counsel to appear in court by handling other matters. And as at 11 a.m., the prosecuting counsel, that is Ms. Wangia, had not appeared in court. There was no counsel to hold the prosecutor's brief to explain her whereabouts. Upon taking the quorum, this court was informed by the counsel watching brief for EACC that she had sent a text to her indicating that she is indisposed. This communication had not come from the DPP. This conduct of the prosecuting counsel smacks of utter contempt of the court and an insult to the dignity and integrity of the court. As the matter stands, the prosecuting counsel and the DPP have absconded their duty of discharge, have absconded from discharging their duty. Through their action, they have held the court at ransom, making it impossible for the court to discharge its mandate under Article 159 and Article 50 of the Constitution, which requires it to do justice to all and to do it expeditiously. The DPP has abandoned his duty and instead usurped the role of the court to manage the trial process. He is now purporting to direct the court when and when not to proceed with the case. This court has a constitutional protection under Article 160. Just let me confirm, please. Under Article 160 of the Constitution, which states that in the exercise of judicial authority, the judiciary as constituted by Article 161 shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any other person or authority. The DPP has no power whatsoever to control the proceedings of this court. This court had pronounced itself on the 7th of November 2023 when the prosecution sought to adjourn the hearing date and take out all other hearing dates pending the hearing and determination of their application dated 3rd of November, in which they are seeking to withdraw the case against the 10th, 11th, 12th, and 13th accused person. This court, in denying the application for adjournment and taking out of those hearing dates, stated that whereas the application is only in favor of 4 accused persons out of 17 accused persons, the application for adjournment is not justified to pend the trial for the rest of the 13 accused persons who are also entitled to have their matter proceed expeditiously. There was a witness in court who gave evidence on the 7th of November 2023 and was due to come for cross-examination on the 8th of November 2023. It is on 8th of November 2023 that the prosecuting counsel went missing without a word. Today, the 9th of November 2023, the prosecutor has again gone missing without a word from the office of the DPP. The conduct of the DPP is wanting, and I'm guided by the decision of the High Court in revision number E010 of 2023, where Justice Sifuna at paragraph 20 at paragraph 21, which states that the prosecution should find a more honorable and sensible way of abandoning its own case. Paragraph 23 also states that a public prosecutor must conduct the case in a manner that promotes the public interest and the public good. To abandon these two aspirations and embark on advancing the narrow agenda and private interest of the defense is an abdication of public duty. The motivation for such dereliction of duty could only be spurred by inter alia Kenya's lack of formal mechanisms or outfit for holding public prosecutors liable for negligent or willful loss of cases. Had we any, that's at paragraph 24, such clear sabotage, frustration, scattering, and the bungling of cases would be a thing of the past, especially when the cases involve a public agenda, national security, safety of the citizenry, or arise from the loss of public funds, such as in this instant case. Parliament or the Office of the Public Prosecution itself ought to develop regulations for making public prosecutors accountable for the manner in which they conduct cases and hold them accountable for negligent as well as willful, premeditated, and connived loss of cases. End of quote. It is unfortunate that the prosecution has chosen to get an adjournment through sheer untwisting of the court. The defense has sought to have the matter terminated under Section 204 of the Criminal Procedure Code for the failure of the complainant to appear in court. Indeed, this court takes notice that the prosecutor is the complainant in all criminal hearings. And where the prosecutor fails to show up in court, then there is simply no case against the accused person. However, this court takes notice that the matter before it is a public interest case, and the sins of a prosecutor or the DPP cannot be visited on the public to warrant the interference of justice. It is for this reason that I decline to dismiss the case for want of prosecution, and hereby declare that the conduct of the prosecuting counsel and the DPP is contemptuous. The matter is hereby adjourned for today, but on condition that this ruling shall be placed before the National Council of Administration of Justice for a dialogue on the conduct of the prosecution in this and other cases. The ruling shall also be placed before the DPP. That is all.
Your Honor, we appreciate the difficulty that this. We appreciate the difficulty that this court finds itself in these circumstances. I can't promise the court that we will not be thinking about taking other action, particularly in the High Court, in the light of this. Your Honor, there is this letter that was written to the court yesterday. I speak on behalf of the defense that we ought to have been given a copy of that letter. Could Your Honor direct your staff that letter be forwarded to us? They have our email addresses. Thank you.
After the application is allowed, the letter will be forwarded to all the defense.
Thank you. Thank you, Your Honor.
Similarly, Your Honor, thank you for your ruling. Yesterday when we appeared before Your Honor, I had informed the court that we had an application that had been filed by the 17th accused person and that the same had been served on the DPP. Seeing as that the same was supposed to be dealt with today, we've not received any responses. We'll be seeking that the same application be allowed and the accused person be allowed to travel out of the country. His passport released to him and allowed to travel out of the country.